Our speaker today is the Honourable Sheilah Martin, Justice of the Supreme Court of Canada. Justice Sheilah L. Martin holds a Bachelor of Civil Law and a Bachelor of Common Law from McGill University, a Master of Laws from the University of Alberta, and a doctorate from the University of Toronto. Justice Martin worked as a researcher and law professor at the University of Calgary from 1982 to 1986, and from 1991 to 1996, she was acting dean and then dean of the University of Calgary's Faculty of Law. Until her appointment to the bench, Justice Martin first practiced criminal and constitutional litigation and then civil litigation in Calgary. She appealed at all levels of court, often at the Supreme Court, and was awarded a Queen's Counsel designation. Justice Martin was appointed to the Court of Queen's Bench for Alberta in 2005 and served as a deputy judge for the Supreme Court of Yukon from 2009 to 2016. When she was appointed to the Courts of Appeal of Alberta, the Northwest Territories, and Nunavut. She was appointed to the Supreme Court of Canada in December 2017. She's been involved with judicial education throughout her career, and we're pleased to add Justice Martin's name to the list of esteemed speakers who have delivered the Saskatchewan Law Review Lecture over the years, and look forward to hearing her speak about juries today. Justice Martin. And one final point, Justice Martin will not be taking questions at the end, so we have wisdom for an hour at most. So we look forward to it, and Justice Martin, over to you.
Well, thank you very much. I am delighted to be here today and to join the list of the prestigious speakers before me. I'm a little intimidated by that list, but I am glad to be here today. I came to university. It was January, and I was very nervous, and I thought, well, I'll walk from my downtown hotel and I would walk out. I can just say that that was the time before Google Maps. I understand what I was getting myself into. And as people who have done criminal law have heard this expression, it seemed like a good idea at the time. But by the time I got there, of course, I was completely frozen. And to this day, I don't even recall how that interview went, because my fear was that my brain was frozen. When it thawed, it turned to mush. And so I have a very, very modest goal being with you here today. And that is that you don't think that the COVID or the cold has made my brain frozen again today. So I am delighted to be here, and I'm really quite excited about the topic. And I look forward to preparing my paper version as well. And it's simply because it's such great fun to come to a university and explore ideas about how people think and how people may learn to think in different ways. As you've heard, I was a trial judge for about 13 years, but I was a law professor for many more. And I spent decades in a classroom trying to figure out and find ways people could understand and absorb new knowledge so that they could apply it to new facts, to convey information in a simple and approachable way, and to create those aha moments of deep comprehension. And as an academic and as a barrister, I worked on many education programs, some for lawyers, some for judges, which took into account the principles of how adults learn. So the pedagogical theory about how best to convey things to people who already have life experience. And many of those initiatives revolved around what equality requires and what discrimination looks like. And so in recent years, through case law and accumulated experience and judicial education initiatives, we've gained a deeper understanding of what impartiality means for judges. And I think we can say that it's widely accepted that decision makers are expected to be impartial, neutral, and objective, and to decide only based on the evidence presented before them. Clearly, what is not required is the personal opinion of the judge, but the application of reason and principle bounded by law to evidence. And so that is a fundamental norm of the criminal justice society. But there's also another foundational value, and that is that there should be equal justice for all. And that means, under a substantive equality approach, that all individuals before the court, whether accused or witness or victim, are to be equally deserving of consideration, dignity, and respect, and that there should be no discrimination against people in a courtroom based on their group affiliation. We have, I think, over time and with experience, expanded our understanding of what judicial impartiality is and what it requires. And we've come to appreciate that a core judicial competency is the need to understand the different life circumstances of those who are marginalized, racialized, and otherwise disadvantaged. And for courts to go behind the imposition of a uniform norm to assess what the law's actual impact is on those that are subject to it. Now, judges are expected today to understand the social conditions of the diverse population that appear before them and to make decisions that do not include outmoded or unproven assumptions, unreliable stereotypes, or even prevalent social myths. The law of sexual assault, I think, provides a robust example of the hard work that it takes to enact inclusive laws and to cleanse decision-making from unreliable attitudes, which distort the trial's main purpose as a truth-seeking process. And indeed, today, if a judge reasons based on certain old ideas or unacceptable myths or stereotypes, an appellate court may intervene. We see serious infringements of impartiality as reviewable errors of law. And we have therefore learned a great deal about how to ensure that judges act impartially and in accordance with the foundational and formative values of substantive equality. That got me thinking about the fact that jurors and juries are also legal decision makers who play a crucial role in our criminal justice system. We do have obligations for jurors to act impartially. That's not contested. But is juror impartiality the same thing as judicial impartiality? How is it different? How do we ensure that juror impartiality also includes the equality underpinnings that have not traditionally been explored with significant detail or depth? And we can't be indifferent to the multiple dimensions of that question. And so in terms of thinking about, people were more familiar with the notion of impartiality, talking about my responsibility around impartiality applied to jurors, patients of everyone entrusted to determine criminal culpability, whether the election was. However, the question becomes, how can impartiality be guaranteed and explained to people who usually sit in judgment of others on one occasion only, and that is when they're called for judgment? Can we translate the lessons we've learned about judicial impartiality and what we to heightened judicial objectivity? Can we translate that or transpose that into the jury context? And to explore this question today, I thought I would first set the stage briefly and talk about the importance of juries, and then outline exactly what it is that they do. And then I would like to talk about judicial impartiality and decision-making, and to explore the ways in which we can use similar concepts in relation to jurors, and to inquire into what steps can or should be taken to ensure that jurors understand the full extent of their responsibilities, which includes not just impartiality, but again, that heightened objectivity and awareness, which comes from an understanding of the diversity that exists in society. So let's start then with why are juries important? Well, we've always called them a cornerstone of our criminal justice system. They've been making determinations since the 13th century in England, and they started sort of a little bit by accident when the church decided that its priests would not be allowed to engage in trial by ordeal. But we know that from about the 18th century on, Blackstone was extolling a jury as a palladium or bulwark of liberties in England, and we can see that that notion of the centrality of a jury trial has been pulled forward into the Canadian Charter and exists in Section 11D, the right to a fair trial before an independent and impartial tribunal, and Section 11F, the right to the benefit of a trial by jury where the offense is punishable by a term of imprisonment of 5 years or more. And Chief Justice Dixon, in the case of Corbett, helped explain why a trial by jury is so venerated in our legal culture. He said the following: "The very strength of the jury is that the ultimate issue of guilt or innocence is determined by a group of ordinary citizens who are not legal specialists and who bring to the legal process a healthy measure of common sense." All right. Four main rationales are supposed to exist for the importance of jury trials. The jury is viewed as an excellent fact finder because the jurors must reach a verdict collectively. The jury's representativeness allows it to act as the conscience of the community, and the jury is seen as the final bulwark against oppressive laws or their enforcement, usually in terms of jury nullification. And lastly, by involving the public in the criminal justice system, the jury enhances public understanding and trust. But we know from what Justice Leroux Dubé said in Sherritt that the right to jury trial is meaningless without some guarantee that they will perform their duties impartially and represent as far as possible and appropriate in the circumstances the larger community. Now, the question of who is that larger community, what kind of representation is required, who is a jury of my peers, that's an old and very contested concept and has been debated as long as juries have been in existence. There are a host of questions around how we should interpret community and what the selection process should be designed to facilitate. And these are very important questions because, as we know, who sits around any decision-making table is always important. But the inquiry that I want to explore today is not that question. It's a different question. My question sort of starts once the jurors have in fact been selected. And once they are selected, how will they understand their obligation to be impartial? And how can we try to inculcate the same understanding of impartiality we expect from other types of judges? So let's stop for a moment and just take a look at what jurors do. This to me is completely fascinating. Now, of course, very, very simply stated, the juror's job is to determine the accused's guilt or innocence. But there's absolutely nothing simple about what we ask of jurors. The accused is placed into their hands and they're asked to reach a verdict. This is a very high-level skill. It is a complex, multi-staged process involving much information and many, as I said, advanced skills. They are the judges of the facts, so they have to determine what evidence they accept, and this often arises from competing versions of events. They can accept all, or none, or some of any of the witness's testimony. They sift through that testimony and documents to determine and piece together what actually happened, and they choose between expert evidence concerning the likelihood of certain actions and the acceptability of various opinions. And they assess the credibility of witnesses. And trying to determine which stranger is telling the truth and to ascertain their capacity for recall and the reliability of their narratives is, as any trial judge will ever tell you, a task of monumental importance and great, great difficulty. So the jurors are going to be instructed then on the law and required to both learn and accept the legal principles explained to them by the trial judge. And this often includes making very fine distinctions about permissible and impermissible ways in which evidence can be used. And so jurors must then also systematically consider the constituent elements of each offense. This is always a challenge, and it's no small matter if there are many multiple charges on the indictment. Now, the jurors ascertain whether the Crown has proven its case beyond a reasonable doubt, and they're going to have to grapple with the level of certainty this very key concept of reasonable doubt captures. So, and they'll also have to put forward any defenses by the accused, and ultimately they will have to apply all of that they've learned to the facts as they have found them. Now, I'm going to pause here for a second and say that I am at a law school, and so if you're a law student sitting there today and saying, my goodness, that sounds complicated, and it sounds worse than a really bad law school exam question, you would be correct. It is a very, very difficult thing that is being asked. And as someone who sat as a trial judge for about 13 years, I'm struck by how what we ask of our lay jurors is very similar, if not identical in certain respects, to what it is that we expect of the process employed by our judges. Trial judges sitting alone will also have to decide facts, assess credibility, understand the law, and apply it correctly to the facts as found. Now, there's no doubt that the trial judge is also sort of the gatekeeper of evidence, the guardian of the Constitution, and is ensuring that the process and trial is fair at the same time. But there's so many similarities, and it's understood that a trial judge in each part of that multi-stage skills-based process is required to be impartial and is required to interrogate his or her or their own ideas about how to go about assessing facts, determining credibility, applying law to facts, and making sure that they are taking an expansive view of all of that so that they can bring not just impartial justice, but equal justice for all. So this is what leads me to ask the questions that I'm posing today. What can we do with that knowledge in respect of jurors? Now, I think we have to really start and understand from the jurors' perspective that we ask a lot as a society of our jurors. They leave their personal lives to perform what is an essential civic responsibility. It is an exceedingly difficult public role of determining guilt, or in a sense, according to law. And they are literally summoned and thrust into the courtroom, which is unfamiliar to them, perhaps even foreign. And it's going to be a place that would be intimidating to many. Most people's experience with a jury trial comes through books or films or television shows. And there's no doubt that there's a reason why a jury trial is often the subject of artistic inquiry. And that is because a trial is often a morality play. And a jury trial provides higher drama still. There are people who are testifying about very difficult matters, who are subject to the rigors of cross-examination. There is a search for truth and a quest for accountability. And as the accused faces a loss of liberty, the stakes are always going to be high. And so we know that our jurors will probably have no personal experience in this realm, and they will often be a juror only the once. And the process of deliberation is secret. And while they're asked to be unanimous and are therefore engaged in collective decision-making, at the same time, each juror is ethically obliged to exercise their own independent judgment. It kind of sounds a lot like sitting on a collegial court of appeal, that mixture between collective and personal. And every person who has ever sat on a jury understands just how hard it is to sit in judgment of someone else, to try to understand what happened and why, especially when the circumstances of what's being described are far removed from their own personal experience. So I think we have to stop and pause and understand that this is a very difficult task, and that from my own experience, I believe that jurors really want to do a good job. They really want to get it right. And to do that, they will obviously need assistance from the trial judge. Many, many different kinds of assistance. And what I'm trying to explore today is what assistance do they need in respect of understanding the lives of others, and in terms of impartiality and equality. Now, we know about impartiality and equality from the judicial side. We have done a lot of exploration, and indeed some of our notions there have changed. The basic idea is that judges must be free to decide honestly, impartially, in accordance with law and evidence, without fear or concern or interference or improper influence or control, that there needs to be an overlap with independence. But impartiality is directed to a type of fairness, which ensures that cases are determined on the basis of the evidence and their merits, and according to law. And we're talking about an ideal of fairness. And an impartial person is one who acts in a fair manner between all parties in a case appearing before them. And we're told in the case of Valenti that both independence and impartiality are fundamental, not only to the capacity to do justice in a particular case, but also to individual and public confidence in the administration of justice. So the modern day juror is expected to be impartial and an independent trier of fact, rather than a neighbor or a witness. And we have to recognize that all decision makers bring their life experience and perspectives with them when they sit in judgment. The notion of a judge or a juror as a blank state or neutral cipher is now recognized as an old idea that never really reflected reality. Cardoza recognized that decision makers bring a mental background to the task before them, made up of, quote, inherited instincts, traditional beliefs, and acquired convictions. And we have learned through exploration and study that impartiality requires an open mind, but not an empty one. And our court recognized in RDS that not only can decision makers never be expected to be completely neutral, the trier of fact must draw on their experiences in performing their tasks. So the process of assessing evidence, drawing inferences, evaluating credibility, anything that would involve inductive reasoning, usually depends on common sense, logic, human experience. And there is value, we say, in decision makers drawing on their experiences and unique perspectives. In the case of judges, society benefits from the valuable knowledge gained by the judiciary while they were members of the bar. And as I said in RDS, expecting judges to divorce themselves from their prejudicial lives and perspective would preclude the achievement of a diversity of backgrounds in the judiciary. And in a collective decision-making body, a diverse range of perspectives might be expected to improve the quality of deliberations, especially for jurors where unanimity is required. So given that we accept decision makers will situate the task of decision making against the background of their own experiences and insights, what does it mean to be impartial? Well, in the words of Justice Edwin Cameron, impartiality is not, quote, colorless neutrality, but rather the quality of open-mindedness and readiness to persuasion. Hutchison describes the relevant quality as a recognition of one's predispositions and a constant willingness to reinterrogate them. So in Canada, this notion of impartiality must also be situated and understood in the context of the Canadian commitment to substantive equality. In the Williams case, Justice McLaughlin, as she then was very clear that the right to an impartial jury is also an anti-discrimination right, saying at the core of the guarantee in Section 15, as the application of racial stereotypes to the accused prejudice is among the most destructive forms of discrimination. Okay, so a twinning together of impartiality and substantive equality. And if we look from a judicial perspective at the Canadian Judicial Council's ethical principles for judges, they do insist on impartiality, but go forward and expressly tie impartiality to the judicial, quote, commitment to equality before and under the law and equal protection and benefit of the law without discrimination. Should sound a lot like Section 15. And they say as following, this is a quote, equality according to law is not only fundamental to justice, but is strongly linked to impartiality. A judge who, for example, reaches a correct result, but engages in stereotyping, does so at the expense of the judge's impartiality, actual or perceived. And these principles, that's the end of that quote, but the principles then go on and they warn that judges are not to be influenced by attitudes based on stereotype, myth, or prejudice. They advise that the judges must be diligent in recognizing their own biases and correcting them. And so we have come to a point where, as a legal norm in certain circumstances and as an ethical obligation for judges, it is incompatible with equality to allow stereotype, myths, and prejudice to infiltrate the reasoning process. And Professor, now Judge Alice Woolley, tells us that it's not only that, but it also destroys or distorts the truth-seeking process. Justice Woolley has aptly described what a failure to imagine what it would be like to be someone else can do to a decision maker's ability to find fact. She says the following, you will simply fail to appreciate the evidence before you. You will draw the wrong inferences and make the wrong findings because what you think you see will not actually be what happened. All right, so a fear that a failure to take into account existing perceptions may stand in the way of coming to the appropriate conclusion in terms of finding facts, drawing inferences, and applying them in a legal setting. And we can see this in terms of the twin myths and sexual assault cases were examples of this, and was from the Barton decision at the Court of Appeal in Alberta and then at the Supreme Court of Canada, where there was a pointing to many of the types of myths and stereotypes that can arise that may have a negative impact on the decision-making process. And in that case, it was a sex worker who had entered a transaction with a client. The stereotype was that was given implied consent to absolutely anything that client may have wanted. And so we see that the unconscious or implicit biases can impact credibility as well, making it easier to accept that a particular accused committed the crime, and that we have to be on guard as judges that preconceptions will shape the information that's received during the course of the trial to conform and to confirm the bias. And so implicit bias is a very large topic now of discussion and research and inquiry. And it can be defined as those implicit attitudes and stereotypes that are not consciously accessible through introspection, but they can function automatically. And we know in the judicial context that courts have accepted the widespread nature of implicit or subconscious biases. For example, many, many years ago in the 90s in Parks, Justice Doherty from the Ontario Court of Appeal noted that a large segment of the community, quote, holds overtly racist views, close quote. And then goes on to say, quote, but a much larger segment subconsciously operates on the basis of negative racial stereotypes. And anti-Black bias has been said to rest on unstated and unchallenged assumptions learned over a lifetime. And these assumptions may shape day-to-day conduct, often without conscious reference to them. And so, for example, we see that portrayals of Indigenous women and girls in the media may have resulted in dehumanization, perpetuating the assumption that they are less than non-Indigenous people, that they are not worthy of the same rights and protection as Indigenous people. It's a quote from the report on missing women. So how do we, knowing all of this, how do we help decision makers, whether judges or jurors, protect against these pernicious and distortive influences? Now, sometimes those changes have taken place in the law itself. Sometimes those changes have taken place in viewing something like the use of a stereotype as an error of law that can be reviewed. But very, very often, or I can give you another example here, is that a stereotype might be that all victims of sexual assault, including children, will report in a specific way at a specific time. We used to know about you had to make a hue and cry afterwards. The law changed. But the notion that someone would complain right away about such a serious violation, in our case law, we've said that's not necessarily the case, that there's no one model of having been a victim of a sexual violence, and that we can expect that there is often delayed disclosure, and especially among children. So if a judge used that principle to reason on, that could be seen both as partly legislative, partly in terms of the judicial reasoning process, but could amount to an error of law leading to a reversal of verdict. And we've also learned all of these things through social context education as well. There has been very great movements to make sure that judges understand the life circumstances of everyone who appears before them, and that judging is grounded in the human condition in the society in which it takes place. And it's been described, social context education, as taking, from the model of Justicia, who has on the blindfold, of sometimes we need to remove the blindfold to understand what is going on, because ignoring difference or taking this type of colorblind or abstractly neutral kind of behavior is not conducive to fact-finding or substantive equality, or even to public confidence. Nadelsky says what we have to do is engage in an enlargement of mind, a process that's described by Justices Leroux-Dubé and Justice McLaughlin at the time as an essential precondition to impartiality. And when she was Chief Justice, Beverly McLaughlin explained how education on social context enhances impartiality and public confidence. This is what she said: every judge should have an appreciation of how the powerless and the poor live. Every judge should appreciate the importance of maintaining respect for the administration of justice in all sectors of the community. Judicial education on racial and gender bias has proved a powerful tool in rendering our justice system more egalitarian and moving judges from the partial vision to the impartial vision. And the question then becomes, can we translate what we've learned of moving from the partial vision to the impartial vision, to the vision that takes into account this heightened judicial objectivity? Can we use that with jurors? Can we ask jurors, and how do we do it, to lift the blindfold when they're judging to see the wider context? Now, I think that there's some differences between them, which might suggest that how such a thing could be accomplished may vary. But at its core, we know that the notion of impartiality underpins so much of the jury process. At its very basic, people who have a conflict of interest, how the jury role and the requirements for the juries, who is allowed to sit, they have to be able to do the job. And sometimes the regulations and set by the provinces disqualify people based on the assumption that they're not going to be indifferent as between the Crown and the accused. And when we're in the courtroom, we see that there are other reasons or other mechanisms that are used in an attempt to try to convey the need for impartiality. They include screening for conflicts of interest, challenges for cause, and the enhanced stand-aside power under the new jury selection regime. We know that a juror who is too close, or because they know one of the parties lacks the requisite impartiality. Very interesting, Martha Minot has raised the question of whether a juror, though, can be too far from the case to judge impartially or fairly. She queries whether it's possible, in her words, possible to risk actual bias or its appearance by having a total absence of experience or knowledge of the issue or evidence at hand. To be able to evaluate states of which, a jury needs sufficient knowledge of the witness's world to place their statements in context. Moreover, to be able to render judgment, jurors need sufficient knowledge of the life experiences of those before them to make sense of testimony and motivation. And this kind of approach would suggest a more robust and equality infused vision of impartiality, and that one, and at the very least, calls upon us to look at the mechanisms that we currently use and can adapt or even introduce that may increase the possibility of having this true version of impartiality. Now, I look for a little bit of guidance here to the challenge for cause kind of idea, whose purpose is directly to root out impartiality based on pretrial publicity or any other factors. Often in our society, it's when there is an interracial element to the crime and the jurors being asked whether the fact that, for example, that the accused is Aboriginal and the victim is white, would that affect their ability to decide impartially? Those are the kinds of questions that may arise under challenge for cause right now. But what's so interesting about the challenge for cause proceeding is that it shows in a very concrete way just how important impartiality is, because it says, look, we have a process here that protects and promotes impartiality. We will screen people out if they are not able to render this kind of impartial judgment. And to me, that's a very important message, symbolic and practical, that is being sent. The medium there can be the message in the sense that it's saying, we're going to take the time necessary to ensure that this important value in our judicial system is being preserved in this particular instance. And so we can learn from that, and we can learn what we've also learned about jury instructions. We have learned so much in recent years about how to convey information to juries according to adult learning principles. So we have now model jury instructions. We have great care being taken that they're in accessible language, that things are repeated or reinforced and presented in a way that we can assist juries in the very hard task of trying to apply recently learned law to new facts as they've just found them. And so we have learned a great deal there. And if we understand that judging, whether done by judges or jurors, is a public service bounded by law, we also know that part of the law that needs to be explained to jurors is the kind of impermissible reasoning that cannot take place. Just like they are not allowed to use hearsay evidence for the truth of its content, there also will be certain myths or stereotypes or assumptions or preconceptions that will also have the potential to taint the decision-making process. And we know it's absolutely key that those things are not involved. I mean, the reasons that we established these strictures for judicial reasoning were very simple. It was to protect fair trial rights. It was to protect that that it was an impartial process, that people were being treated equally in our courtroom, that the standards require bias-free reasoning. And so for all those same reasons, jurors can be expected to need to know the same things that we now say judges are required to learn. And that's because at the fundamental, we understand that equal justice requires that cases actually be tried and decided on their merits. And so impartiality is a crucial qualification, and clear communication is key. And jurors need to know and are entitled to know beforehand what conduct is expected of them, so that they can not only produce it in themselves, but they can insist upon it in other people. And so there will be different ways that we'll have to deal with it, because of course jurors are ad hoc. They serve their function and they're disbanded. It's not like a judge who can study over a lot of time. There's very few opportunities to refine what the juries do. Juries aren't selected based on educational and professional qualifications as judges are. The guiding principle is one of random selection, subject to challenge for cause. And we know that juries deliberate in secret, and they don't provide reasons. And so it's very difficult to know the basis on which a decision was reached. And it's also difficult from a research perspective to understand what motivations may have led to a decisions, and how to best go about dealing with how to make sure that those things that shouldn't happen are not in fact happening. But we know that we must rely on juries' common sense and experience. And indeed, we tell them that very, very frequently in jury instructions. But the problem with common sense and experience is that, as LaRue Debay said and C. Boyer, sometimes it's this very reliance on common sense and experience, which allows stereotypes and biases to creep in. She said, in some areas of inquiry, experience, common sense, and logic are formed by stereotype and myth. And so we need to take a serious look at that and say, how is it we should go about dealing with this? Well, we know that jury instructions are very, very significant, and they have set the standards for how jurors approach their tasks. And so if we're talking about stereotypes and the like, perhaps what we need to be thinking about is how to start the trial with appropriate advisories, and how to go through and to ensure that at every juncture there is a repetition of any necessary guidance about making sure that impartiality is there. It needs to be explained, and it can start from when the array comes in right up until the last moment of sequestration. It is a message worth repeating, and it's worth repeating when necessary, because there is not much time in a jury trial to inculcate the necessary values of impartiality, neutrality, and fairness. And so if it's reinforced at every available or opposite opportunity, the jurors will come to appreciate its centrality to the demanding and difficult role that they have. And it's very important in this context that impartiality be expressly explained and consistently reinforced and tied to the notion of justice for all. We have learned through much research that pretending a problem doesn't exist does not in fact help. And for example, in the context of racism, mentioning race and making race, as Lee says, salient, helps people to understand their biases, and that they cannot understand how bias may affect their decision unless they're aware of them. And so Blackman said many years ago, in order to get beyond racism, we must first take account of race. And so in line with the social scientific research, the Court of Appeal and then the Supreme Court in Barton emphasized that instructions can, I quote, expose biases, prejudices, and stereotypes that lurk beneath the surface, thereby allowing all justice system participants to address them head on. And so providing specific guidance about what it means to be impartial and how to remove stereotypic or improper reasoning is a very important thing. And from my own experience, something that is express and specific is usually a more useful learning tool. If you say to somebody who's a juror, you must only decide this on the basis of the evidence before you in court. And the juror says, yes, that's fine. And then says, well, I didn't understand what happened today in court, so I'm going to go and check with Dr. Google and do my own research and find out about this medical evidence because I didn't understand it. And I want to be a good juror and I want to be informed. Because there's ways then of that juror explaining that they will focus on the evidence. This isn't evidence, this is just background. And but if you use, as we do now, a jury instruction that goes further and says things like no tweets, no internet, no research, and we specifically outline what is and is not acceptable behavior, that has aided jurors very much in understanding that they cannot go out and research themselves. And a similar kind of approach can be taken in respect and should be taken, we're told, to jury understanding of what is permissible and impermissible assumptions and stereotypes to be using. The judge's instructions can provide jurors with a framework or yardstick for understanding the tendencies of their own thinking and that of other jurors, and it will become a standard against which to measure the comments of fellow jurors. And this point is absolutely critical. It might not be enough to say you must be indifferent between the Crown and the accused, or you're only to decide on the basis of evidence and not show sympathy or passion or favor to any party. In the Barton case, again, there's an admonishment that this kind of instruction may not be adequate in some circumstances where, for example, issues of race or gender or class or culture or religion may arise that may require a more specific commentary on the kinds of thinking that may get a juror and therefore the administration of justice into trouble. And by setting out expressly what impartiality requires, jurors, as I say, are first of all told what's expected of them. There's going to be a check and a balance, and there's going to be a clear communication of expected behavior, and it shows that there is a limit, and that limit is impartiality and fair trial rights and equalities. It will be a break. It will help jurors slow down their decision-making process to do things that judges do all the time when we interrogate our motivations for thinking certain things and evaluating whether or not we are meeting the community norms expected of us. Questions I used to ask myself all the time as a trial judge. Am I being impartial? Am I being fair? Why do I think this person is telling the truth and this other person is not? Are there limits to my common sense and experience, which I need to acknowledge to fairly judge people whose lives are different than mine? And most importantly, given that I don't know what I don't know, how can I make sure that I'm not making a mistake? Now, there's many other things that are being discussed now. A lot about unconscious bias, a lot of jury instructions. We can look to the UK, we can look to the United States, we can look to Australia. Everyone is thinking about this issue and experimenting with them. But what is so interesting to me is our court is also taking this seriously. Justice Moldaver and Barton suggested that trial judges should explain to jurors the long history of colonization and systemic racism in Canada. And what is so interesting there is that if we set out that kind of information, and if we set out those kinds of norms, we not only, as I say, explain to jurors what's expected of them and put that break on decision-making to allow them to pause and to ponder their personal attitudes. But it allows them to have a yardstick against which to measure the behavior of other jurors. And because of the juror secrecy, we don't know what goes on in those juror rooms. So if that juror comes in with his own research, you want the other jurors to be able to say, you shouldn't be doing that. That might taint our decision-making process. And similarly, if somebody comes in and the judge, for example, has admonished them and explained to them that they're not to look at this victim with less respect, dignity, or consideration, because she was a sex worker and Aboriginal. If the juror is told that, if someone in the juror room starts to speak in those terms, they know, other jurors know that this is not part of common sense and experience that they get to bring to bear in the decision making. They understand that it is something that is outside the boundaries of permissible decision making as a juror. And that to me is a very important inquiry. Let me just wrap up here. And you know, I was an old professor. I can take an hour. This is quite remarkable here. But my goal today was to explore some questions with you about whether we can take what we've learned about the relationship between judicial impartiality and equality and use it to help the administration of justice in the jury context, and to apply principles like heightened judicial objectivity so that jurors are given all of the new tools that they need from the beginning, from the instructions, from mid-trial instructions, in the instructions, in answers to questions, in all formats where they need assistance, to be given full assistance so that they can make decisions in accordance with the fundamental principles of impartiality and equality. And just like a judicial decision is not the personal opinion of the judge, so too must every individual juror understand the strictures under which they are asked to decide the guilt or innocence of somebody else. And we need to think very carefully how this can be done. And this is where I would like to ask for the assistance of the academics and the lawyers and the judges and the jurists and the students in terms of the kind of research and thinking and deep probing and suggesting of options and alternatives so that we can develop strategies together to combat the erosion of true juror impartiality. Let me conclude with a scene from the movie, the classic movie, 12 Angry Men, which follows the agonizing deliberations between 12 characters who were chosen as jurors at the time. And an early sets the tension. The jury has retired and conducts its first poll of each juror's position. 11 hands raise to convict the accused, and one lone juror votes to acquit. Amid the awkward silence and nervous laughter, one juror asks, "So what do we do now?" It's at that point that juror 8 quips, "Well, I guess we talk." So let us use all of our resources to ensure that those jurors are talking about the right things. Thank you.
Thank you very much, Justice Martin. And your timekeeping is remarkable, actually. Yeah, really quite extraordinary. I would have loved to have been a student in one of your classes. My timekeeping is notoriously poor, but there we go. But I want to thank you very much for taking some time with us today and bringing in not only your academic experience, but also experience as a trial judge, and providing a wonderfully informative and thoughtful and challenging lecture that challenges us and my peers and the students to think about these questions and to put the resources of the entire thinking legal community to bear on a very, very important topic. So I want to thank you for that. I also want to, because it's International Women's Day, I want to thank all the women in the room for all the work that they do. And I understand the struggles that they go through. I've been thinking about my mother today because she's 89 years old and she's in a care home in the United Kingdom and she hasn't seen her family for 12 months. But she has been vaccinated and will soon see her family again. But I think about the sacrifices that my mother has made and all the women in the room here who've sacrificed, particularly women who go into the legal profession and the challenges they face. So on International Women's Day, I would like to congratulate all the women in the room for all the work that they do. And I want to thank everybody for their attendance today. I also want to thank again McKercher LLP. This is the last event of this year's McKercher lecture series, and it's been finished in wonderful style. And I want to thank McKercher for their support and hope that at some time in the fall, we will actually be sitting in the moot court room in the College of Law in person, perhaps, watching esteemed lectures in person, and I look forward to that day at some point. I want to thank all of you for your attendance. We had, I think, 135 or 140 people at the maximum, and that's great. And again, thanks to Justice Martin, and thanks to all of you, and have a wonderful day. Thank you, and take care of yourselves. And we'll see you in half an hour, Justice Martin. Yeah, thank you.
All right. Thank you.